Now let's discuss a cruel act by Disney regarding a death at one of their resorts. I have the news article open. Let's dive in. Disney uses streaming service terms to avoid jury trial in park death case. Disney, the company we grew up loving, just committed a cruel act that's going viral. Ever wonder how streaming service terms like Disney Plus can impact real life? Today we'll discuss this Disney case, raising questions about consumer rights and ethics. Can accepting streaming terms prevent someone from seeking justice in court? How far can a company go to protect itself with these clauses? And is it really worth it for them? Stay tuned as we break down the details. To start, you know the drill. Comment below if you actually read the terms of service before accepting an online service, or if you just click OK to quickly open the app or service. I'm curious. I think I know the answer, but I'm still curious to find out. Don't forget to like and share this video link in WhatsApp and Telegram groups so your friends stay informed. Deal, and do share because this is a real shocker. I want to hear your thoughts, all right? Imagine being in one of the world's most famous parks when tragedy suddenly strikes. Now, Disney's defending itself in an unexpected way, using terms from a service few people actually read. According to a New York Times report, Jeff Apicolo filed a lawsuit against Walt Disney Parks and Resorts after his wife died at a restaurant of Disney World due to a severe allergic reaction. He's seeking $50,000 in damages, the minimum to file a lawsuit in Florida court. I think $50,000 is pocket change for Disney. It should have been $500,000, which is still small for Disney, but it's only $50,000. This is nothing compared to losing a wife, for heaven's sake. However, his lawyers believe a jury trial could result in much higher damages, but Disney has a different strategy. They argue the dispute should be settled out of court through arbitration. The company claims Apicolo agreed to this when signing up for Disney Plus in 2019. You know, when you sign up for a service with a free trial, like a free month or 2 weeks, right? And then you can cancel. That's what I'm talking about. Back in 2019, he signed up for Disney Plus's free streaming trial. Disney claims that by creating an account on PlayStation, he agreed to resolve any future disputes through arbitration, including this tragedy. Disney's lawyers also state that the Hagland Road Rich Pub, where the incident occurred, is independent and only has a landlord-tenant relationship with Disney. In other words, Disney isn't responsible. The restaurant is. This claim could further complicate the case, leaving the outcome uncertain. Folks, it'd be much simpler for Disney's image if they just paid the $50,000. If it were $500,000, maybe negotiate, but $50,000? Come on, for heaven's sake. Let's talk about terms and conditions now. Disney's defense in this case is sparking heated debates and raises an interesting question. How far do service terms we agree to without a second thought or reading actually extend? I've been a lawyer for 11 years, okay? Yet, depending on what I'm installing, I sometimes give that quick okay too. I read most, but come on. I'm not signing up for Netflix thinking I might sue them later. Like if I got sick at a Netflix restaurant, if that even existed. It's just such a weird thing, you know? But this Disney news makes us rethink all of this. This month, lawyers for Jeffrey Piccolo, suing Disney over his wife's death, countered the company's arguments. They argued the defense was fatally flawed, stating Piccolo never signed with Walt Disney Parks directly. And even if he had, it wouldn't include his wife. So he signed for streaming, not with Walt Disney Parks, right? Plus, it was him, not his wife. The lawyers also noted that by buying Epcot Resort tickets in 2023, Piccolo agreed to the website's terms and conditions, but these terms didn't mention mandatory arbitration for disputes, specifically the terms on the site where he bought Epcot Resort passes. Those should be considered not Disney's terms. Well, what happened that day? The waiter was informed of the woman's severe dairy and nut allergies, and she chose dishes the waiter said were free of these ingredients. But 45 minutes after the meal, something went terribly wrong. The woman collapsed in a nearby store, struggling to breathe. She tried using her EpiPen but was rushed to a hospital where she was sadly pronounced dead. Now, this case's outcome could completely change how we understand the limits of terms of service and what can be required from those who accept them. Will Disney be able to maintain its defense, or will this case set an important precedent? Was it worth it? Was this a Disney decision solely focused on winning the lawsuit? They want to win and avoid a jury trial, which they'd likely lose, but social media is already aware of the case. It's being shared. I'm making this video, so Disney's plan to keep this secret is already ruined. The damage is far greater than $50,000. What do you think? Comment below. If you liked the video, please like, share, and subscribe. You'll see suggestions for more videos now, which I recommend watching. See you in the next video. Take care. Hey there.